So good afternoon to each and everyone. The topic assigned to me is the law on the contract of sales, and to start with, Article 1458 states that by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. So by this very definition of the contract of sale, we can already tell that there are essential requisites to a contract of sale, and since it is a contract, its essential requisites are the same as the essential requisites of a contract. So first is consent, also called a meeting of minds. This is the definition of contract itself. Mutual agreement or consensus adiam, and this all pertains to consent. The second essential requisite is object. This is the subject matter of the contract. And third is cost. This refers to the price in terms of money or its equivalent. So, going back to the definition of the contract of sale, we can identify again that the essential requisites are there. So first is consent, and not just the consent of one party, but the consent of two contracting parties. Two contracting parties does not literally mean that there are two persons, but two contracting parties that one contracting party is called the vendor or the seller, and the other contracting party is called the purchaser or the buyer or vendee. And this vendor or seller consents himself or gives his consent or obligates himself to transfer the ownership and to deliver a determinate thing. And then this other party, the purchaser, the vendee, the buyer, gives his consent that he will pay therefore a price certain in money or its equivalent. The second essential requisite is the object. So this is now the determinate thing that the vendor or seller obligates himself to transfer and deliver. And the third essential requisite is the price or is the cost, which is the price that the buyer or vendee or purchaser gives his consent that he will pay that in money or its equivalent. So the equivalent of money is explicitly stated in the civil code that could be a check or promissory notes, but not merchandise or goods, because it falls on, kung goods or merchandise na yung binayad, it already falls on Article 1468 and Article 1638, which is the law on the barter or exchange. Kinds of contract of sale. So first is the absolute contract of sale, which refers to a contract of sale that is not subject to any condition or does not require any condition for the transfer of the ownership. The second is the conditional contract of sale, which refers to the contract of sale that contemplates contingency or is subject to a condition. So when the conditions in the conditional contract of sale are already performed or okay na siya, natapos na yung mga conditions na nakalagay doon, then it automatically becomes di na kailangan mag-execute pa ng absolute contract of sale. It is enough na meron na perform na yung conditions na nandun. So the property now is transferred and it delivered, as opposed to the contract to sell, wherein meron din siya, could have conditions, or most of the time contract to sell is done because the payments are in installments. So the difference now is that sa contract to sell, there is still a need for the contracting parties to enter into an absolute contract of sale before the property is transferred and delivered to the buyer, the purchaser, or the vendee. Characteristics of a contract of sale. First, it is consensual. It is perfected by mere consent without any further action. But just because it is perfected by mere consent doesn't mean that the other essential requisites of the contract can be disregarded. It should still have object and it should still have cause. Second, it is bilateral. Both the contracting parties are bound to fulfill correlative obligations towards each other. the seller to deliver and transfer ownership of the thing sold, and the buyer to pay the price. Third, it is onerous. The thing sold is conveyed in consideration of the price and vice versa. So it's not gratuitous, it's not free. It is in consideration of the price. Fourth, it is commutative. The thing sold is considered equivalent to the price paid and vice versa. It could also be aleatory, where there is a sale of hope. So example, selling of tickets or sweepstakes. So there is not really a guarantee that the buyer can have the jackpot price or the money involved in the ticket or in the sweepstakes na binili niya. But it is still a valid contract of sale, even if that it's not really like walang benefit sa'yo yun kung hindi ka mananalo. Number 5, it is nominate. It is given a special name or designation in the civil code, namely sale. And number 6, principal. It does not depend for its existence and validity upon another contract. Article 1479. A promise to buy and sell a determinate thing for a price certain is reciprocally demandable. An accepted unilateral promise to buy or to sell a determinate thing for a price certain is binding upon the promisor if the promise is supported by a consideration distinct from the price. So to further understand this article, we have a sample case here that states, petitioner claims that there was a perfected contract to sale, while respondents argue that what was perfected between them was a mere option. So facts of the case disclose that the receipt that contains the contract between petitioner L and respondent spouses, husband and wife, provides substantiality as follows. Receive from L the sum of 20,000 as earnest money with the option to purchase a parcel of land owned by husband located at blank with an area of blank. Should the transaction not materialize without the fault of the buyer, I, husband, obligate myself to return the 20,000. If through the fault of the buyer, the said amount shall be forfeited. I guarantee to notify L or her representative and get her conformity should I sell or encumber the property to a third person. The option to buy is good within 10 days. So the question is the agreement between the parties a contract of option or a contract to sell? So the answer is it is a contract of option. The above receipt shows that respondent spouses and petitioner only entered a contract of option, a contract by which respondent spouses agreed with petitioner that the latter shall have the right to buy the former's property at a fixed price of 34 pesos per square meter within 10 days from 31 July 1978. Respondent spouses did not sell their property. They did not agree to sell, but they sold something, and that is the privilege to buy at the election or option of the petitioner. The agreement imposed no binding obligation on the petitioner aside from the consideration for the offer. So the next question is the 20,000 an option money or is it an earnest money? So going back to the problem, it is mentioned that it is 20,000 as earnest money with the option. So is it an earnest money or is it an option money? So the answer is it is an option money. The consideration of 20,000 paid by petitioner to respondent spouses was referred to as earnest money, but a careful examination of the words used indicated that the money is not earnest money but option money. Kasi ang difference ng earnest money and ng option money is that the earnest money, there is already an agreement that there is a sale, while option money, wala pang agreement. It's just you have what was sold was the privilege to buy a particular property ahead of the others. And also, sa earnest money, once it is paid, it is distinct from the price. So, once earnest money is paid, then it is understood that the next payments should be paid. The balance for the entirety of the property must be paid, whether in full or in installments. But it follows na kapag earnest money yung binayad, the next payments should follow. And that is not the case for the option money. Article 1482. Whenever earnest money is given in a contract of sale, it shall be considered as part of the price and as proof of the perfection of the contract. So again, it is proof of the perfection of the contract, but still the requisites, the essential requisites of a contract of sale should still be there. Earnest money and option money distinguish. Again, yeah, it is part of the purchase price. Option money is distinct consideration for an option contract. Earnest money is given only when there is already a sale. Option money applies to a sale not yet perfected. And when earnest money is given, the buyer is bound to pay the balance, while the would-be buyer who gives option money is not required to buy. So Article 1483, subject to the provisions of the Statute of Frauds and any other applicable statute, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be inferred from the conduct of the parties. So, as mentioned before, na-stop na, so there is, based on their actions, there is a contract of sale. Form of the contract of sale. The general rule is that the form of a contract refers to how it is executed or manifested, where form is required so that a contract may be enforceable. In case the contract of sale should be covered by the Statute of Frauds, the law requires that the agreement or some note or memorandum thereof be in writing, subscribed by the party charged or by his agent, otherwise the contract cannot be enforced by action. So, under the Statute of Frauds of the Civil Code, the following contracts must be in writing, otherwise they shall be unenforceable by action. Sale of property at a price not less than 500, so kailangan naka-in writing. Sale of real property or an interest therein regardless of the price involved, kailangan naka-in writing. Sale of property not to be performed within a year from the date thereof regardless of the nature of the property and the price involved, again, kailangan naka-in writing. So for those not familiar with the term real property, so it is like land or building or anything attached to land, kailangan in writing siya. So it is not a valid no, it's not valid. I don't think it's the right term, but it should be in writing under the Statute of Frauds if you are selling land or person or real property. And also if it is in installments, itong sample number 3 or yeah, so it should be in writing kung naka-installments. Okay. Where form is required so that a contract may be valid. Where the applicable statute requires that a contract of sale be in a certain form for its validity, the required form must be observed so that the contract may be both valid and enforceable. Where form is required only for the convenience of the parties. In certain cases, a certain form, like a public instrument, meaning it's notarized, is required for the convenience of the parties so that the sale may be registered in the Registry of Deeds to make effective against third persons the right acquired under such sale. I think the contract of sale is valid dun sa dapat naka-in writing, but it is unenforceable if it is not in writing under the Statute of Frauds. Article 1489. All persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Where necessaries are sold and delivered to a minor or another person without the capacity to act, he must pay a reasonable price, therefore. Okay, so let's talk about the kinds of incapacity. So there are two kinds of incapacity. First is the absolute incapacity, which is when the person cannot bind themselves, and relative incapacity, where it exists only concerning certain persons or a certain class of property. There are no other incapacities except those provided by law, and such incapacities cannot be extended to other cases by implication for the reason that such construction would conflict with the very nature of Article 1489. So the question is the sale of property between spouses absolute or relative? So we will know later. For liability for necessaries of minor or another person without capacity to act. So necessaries are those things that are needed for sustenance, dwelling, clothing, medical attendance, education, and transportation according to the financial capacity of the family of the incapacitated person. Generally, the contracts entered into by a minor and other incapacitated persons such as insane or demented persons, deaf mutes who do not know how to write are voidable. So, voidable means it is capable of being voided. Yeah. However, where necessaries are sold and delivered to him without the intervention of the parent or guardian, he must pay a reasonable price therefore. So kung walang intervention, tinanggap nila, kahit binili niya, and then na-aware yung parent or guardian, then it is kailangan bayaran yun. Kahit pa it was done by a minor or by a mentally incapacitated person, for example, or deaf mutes who do not know how to write. As long as it is necessaries. Sale of minors. The courts have laid down the rule that the sale of real estate affected by minors who have already passed the ages of puberty and adolescence and are now in the adult age, when they pretended to have already reached their majority, while in fact they have not, is valid, and they cannot be permitted afterward to excuse themselves from compliance with the obligations assumed by them or to seek their annulment. Kasi nawala na yung good faith. So kahit sabihin nila, I'm just a minor, but at the time that they made a sale of the property, they pretended that they are not a minor. So the sale is still valid. Article 1490. So dito na. So if the husband and wife, if it is relatively or absolutely incapacitated to enter into a contract of sale, the husband and the wife cannot sell a property to each other except when a separation of property was agreed upon in the marriage settlements, in short, if there is a prenuptial agreement. And number 2, when there has been a judicial separation of property under Article 191. This is now something, I forgot the in family code. Arang na, na revise. So this basically means that the incapacity of the husband and wife to enter into contract is just relative, because they can actually enter into a contract of sale, but only for these specific scenarios. When they have a prenuptial agreement, or for example, diba, for the husband and wife, there should always be the consent of the other when they enter into contracts. So even sa BAR, we always look for the consent of the spouse kapag nagsisell ng isang conjugal property. But meron pa rin at times na nakakalusot, perhaps nagsabi yung husband or the wife that they are not married, and then later on nalaman ng wife or ng husband na may biniling property ngayon si husband or si wife, and si wife or si husband gusto niya makuha yung share niya dun sa property na yun, since the husband, for example, use their conjugal money to buy that particular property. So there can be an execution of sale from husband to wife for the share of the wife dun sa property na yun. Relative incapacity of husband and wife. So the husband and wife are prohibited by the above article from selling property to each other. A sale between husband and wife in violation of Article 1490 is inexistent and void from the beginning because such a contract is expressly prohibited by law. They are also prohibited from making donations to each other during the marriage, except for moderate gifts on the occasion of any family rejoicing. Article 1491. The following persons, oh my god, 19 minutes na, cannot acquire by purchase even at a public or judicial auction, either in person or through the mediation of another. So, number 1, the guardian, the property of the person or persons who may be under his guardianship. Di niya pwedeng bilhin yun, or di niya pwedeng i-benta yun. Second, agents, the property whose administration or sale may have been entrusted to them unless the consent of the principal has been given. So, kung sinabi ng principal, okay, I can sell it to you even if you're my agent, or if kung hindi na siya agent, then pwede din yun. So, this is like relative incapacity. Ay. Number 3, executors and administrators, the property of the estate under administration. So for example, a particular person is siya yung executor or administrator ng estate and then binenta niya sa anak niya. So that is not allowed as per the examples that I was reading. Di siya pwede. It's against, it's voidable. Number 4, public officers and employees, the property of the state or any subdivision thereof, or of any government-owned or controlled corporation or institution, the administration of which has been entrusted to them. This provision shall apply to judges and government experts who in any manner whatsoever take part in the sale. Number 5, Number 5, justices, judges, prosecuting attorneys, 21 minutes na. Clerks of superior and inferior courts and other officers and employees connected with the administration of justice, the property and rights in litigation or levied upon in execution before the court within whose jurisdiction or territory they exercise their respective functions. This prohibition includes the act of acquiring by assignment and shall apply to lawyers concerning the property and rights which may be the object of any litigation in which they may take part by their profession. So kung meron silang mga na-acquire ng property ng kanilang client, for example, I think that is void. And any others specially disqualified by law. So this 6, 5, and 4 are void from the start. The contract of sale entered into by these persons are void because it involves the public interest, the interest of the public. While these 3, 2, and 1 are voidable because it only involves the private interest. 2 minutes na. Okay. Next. Article 1492. The prohibitions in the 2 preceding articles apply to sales by legal redemption, compromises, and renunciations. Meaning, yung mga incapacities mentioned, whether it's relative or absolute, does not apply only to the contract of sale but also to sales by legal redemption, compromises, and renunciations. So, the relative incapacity provided in Articles 1490 and 1491 applies also to sales by legal redemption, compromises, and renunciations. Compromise is a contract whereby the parties, by reciprocal concessions, avoid litigation or put an end to one already commenced. It is the amicable settlement of a controversy. So, nagsabot sila nga, sige, dili na lang nato ni padayon ang imong utang sa ko, for example, ani. So if they have the relative incapacity, they cannot also avail this compromise. By renunciation, a creditor gratuitously abandons his right against his creditor. The other terms used by the law are condonation and remission. So condonation and remission kind of the same. Condonation is I think parang nagpardon siya na walaon na lang yung utang. And remission is, what is remission? Cancellation of debt. So basically they have in substance they have the same idea. The persons disqualified to buy referred to in Articles 1490 and 1491 are also disqualified to become lessees of the things mentioned therein. So it's not their incapacities does not just hindi lang siya hanggang contract of sale but also in this sales in legal redemption and availing of compromises, renunciations, and also entering into lease. Article 1495. The vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sale. 24 minutes na. Warranties of the vendor or seller. Under a contract of sale involving real property, the seller is obliged to deliver it and transfer its ownership upon the buyer's payment of the price agreed upon. So this is the consent given by the seller or vendor. And then, besides these obligations, the seller shall warrant the property being sold. Warranties are issued to promise or undertake to ensure that certain facts are or shall be as the seller represents them. Wait. So there are there are two types of warranties. It could be agreed upon by the contracting parties, and that is the express warranties, or it could be as provided by the law, so that is the implied warranties, while conditions must be imposed by the said parties. Express warranties of the vendor or seller. So an express warranty in a contract of sale involving real property exists when it affirms a fact or relates to any promise by the seller relating to the property. Hindi pwede express warranty kung opinion niya lang. For example, I believe, it's in my opinion that this table is the most perfect table in the whole world. And then, pagdating is parang exaggerated lang pala siya. It's not a fact. Hindi pala siya malinis, hindi pala siya up to par, to the standards, something like that. And then the affirmation or promise naturally induce the buyer to purchase the property. And the buyer purchases the property relying on that affirmation or promise. So these are express warranties. Expressly stated or meron talagang express warranties. I think when we buy certain things, there are warranties sa paper na nakasulat. So those things are express warranties. While implied warranties, even if it's not written or hindi nyo pinag-usapan, it is provided by law, which is number 1, the seller has a right to sell the property at the time when the ownership is to pass, while the buyer shall from that time have and enjoy the legal and peaceful possession of the property. So, meron siyang karapatang magbenta ng property na yun. Hindi niya binibenta ang isang bagay na hindi sa kanya. Number 2, the property shall be free from any hidden faults or defects or any charge or encumbrance not declared or known to the buyer. So, there is no defects or hidden faults. Kung sinabi niya brand new. Kung binenta niya ng hindi brand new, dapat expressly stated niya yun. Warranty against eviction, where the buyer would be deprived of the whole or part of the property purchased upon a final judgment based on a right before the sale or an act imputable to the seller. So, yung warranty na, for example, binenta niya yung property niya, tapos later on, may mag-claim na sa kanya pala yun. So, that is an implied warranty na dapat, by the time na binenta niya yun, no one else will be going there to the property na sasabihin, this is mine. Article 1544. Oh my God, 28 minutes. If the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith if it should be movable property. Should it be a movable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property, in the registry of deeds. So, sa una nakapatitle, in good faith, siyang owner. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof, to the person who presents the oldest title, again provided there is good faith. So what is the requirement of good faith? First, mere registration of sale is not enough. Good faith is an essential requisite of registration to acquire a new title because public records cannot be converted into instruments of fraud and oppression by one who secures an inscription thereon in bad faith. So, yung process ng registration of a property, it is made with the idea na it is done in good faith. So the fact that it is in a public instrument, then it is assumed that it is in good faith, but it doesn't mean na hindi na iti-test kung good faith ba talaga ng court. Second, purchase must be for valuable consideration. And it is not only required that the purchaser or real property who has registered the same should have done so in good faith, but also for a valuable consideration. So for example, binili nga niya ng di niya alam na dalawa pala silang buyer, but the value ng binili niya, for example, 500 square meters na property, binili niya ng 50,000, tapos commercial, tapos a should be value of it is around 5 million, for example. So it's not a valuable consideration, and the other party bought it for 3 million, for example. So ma-defeat yung idea na kahit pa good faith, still binili niya ng super barato, talo pa rin siya. Third, continuation of good faith. The mere fact that the second contract of sale was perfected in good faith is not sufficient if before the title passes, the second vendee acquires knowledge of the first transaction. So for example, di niya alam na dalawa silang bumibili. But before the transfer of the title, may nagchika sa kanya na, Mare, yung property na yan, binenta din kay ito. But nag-proceed pa rin siya to transferring the property. Gusto niya magmadali, ay dapat makauna ko og pa-title. Kay duha di ay may buyer. So, na-defeat na again ang good faith. Number 4, burden of proof. So again, good faith is always presumed. It is upon those who allege the bad faith on the part of the possessor rest the burden of proof. So it doesn't mean, again, na since good faith is always presumed, na hindi na magkakaroon ng litigation. I'm not sure if that's the right term. Basta parang the court would still identify if there is indeed good faith. But it is presumed that there is. Good faith, bad faith, a question of intention. Good faith or the want of it is not a visible, tangible fact that can be seen or touched, but rather a state or condition of mind which can only be judged by actual or fancied tokens or signs. So, kaya merong court proceedings. Number 6, property purchased already peaceably possessed by another. A purchaser cannot close his eyes to facts which should put a reasonable man upon his guard and then claim that he acted in good faith under the belief that there was no defect in the title of the vendor. So, for example, he's the second buyer. Pero nung nag-site visit siya, may family na nakatira, may bahay na nakatayo. And then, nagtanong siya sa neighbors, they've been there for 50 years. And then, they're not the seller to you. So, you still continued to buy the property and you registered it to your name kasi hindi titled sa kanila. So, the good faith is already defeated kasi obviously, you should be aware. You are aware. Everyone is aware na sila yung may-ari nun. Number 7, purchaser with notice of the right of the repurchase which has already elapsed. Similarly, one who buys property with notice that it is subject to the right of repurchase from his vendor, the vendee a retro in a previous sale of the property, although such right has already elapsed and there is no annotation of any repurchase by the vendor a retro, but the title has not yet been cleared of the encumbrance, without looking into the right of redemption inscribed on the title, cannot be said to be a purchaser in good faith, for he has noticed that some other person could have a right or interest in the property. Okay, so kung yung title may nakalagay na right of repurchase, tapos obvious doon sa statements, sa annotations na di dapat siya ang maging buyer, but still continue niya pa rin. So again, defeated pa rin ang good faith. Number 8, adverse claim previously annotated on the title of property sold. A subsequent sale of land cannot prevail over an annotated adverse claim which was previously annotated in the certificate of title of the property. So for example, kahit yung isang title na binili niya may annotations, and then gusto niya mawala yun sa magiging title niya, I don't think that is possible because di papayag ang ROD na bigyan siya ng title ng hindi maki-carry over yung adverse claims na yun because they have the right to the property before siya. Number 9, purchaser examined only by the latest certificate of title. So that a purchaser may be considered as a purchaser in good faith, it is enough that he examines the latest certificate of title. So kapag nakita niya yung certificate of title, malinis, walang mga annotations, binili niya, so that is good faith. everything is good faith. So kung merong isang nagsabi na ganito, akin ng property, blah blah blah, then may laban siya because he or she saw the latest certificate of title and it is it is clean. Okay, so that is the end of my report. Thank you for listening.